Good morning, good afternoon, depending on where you're located. And thank you all so much for joining us today. I was so excited to see so many practitioners, including ones from our August Schools community joining today. We're just thrilled to have such a strong group of school counselors, social workers, psychologists, and so many more here for this conversation. So really quickly, for those of you who may not be familiar with August Schools, we're a documentation platform for school-based mental health practitioners who are looking for a way, sort of a secure way to document visits with students. So documenting in this way allows you to see what your student community is struggling with at a glance to help drive that proactive programming and support students in the way that they need. So one of the social workers who uses our platform, who I believe is joining here today, shared how he uses the data in August to see which are the most common CASEL competencies students are struggling with. So that way he knows how to plan programming for the next semester. So that's the power of data and having a deep understanding of the students in your community. And the August Schools platform was built to support the amazing work that you all do every day. So we're really excited to get to host these webinars that will hopefully provide some helpful insight on important topics like this one. And I'm also really excited to introduce the newest member of our August Schools team, Chloe. She's joining the team after working as a clinical psychologist at a school in Connecticut. And we feel so lucky to have her perspective and her experience on our team. So with that, I'll hand it over to Chloe to introduce our special guest for today's webinar.
Thank you, Victoria. Hi, everyone. It's my privilege to introduce our speaker today, Dr. Carolyn Stone. Dr. Stone is Professor Emeritus of Counselor Education at the University of North Florida and a past president of the American School Counselor Association. Over the course of her career, she has been a driving force in shaping ethical practice and professional standards for school counselors nationwide. Before joining UNF, Dr. Stone spent 22 years serving students in Jacksonville's public schools as an elementary and high school counselor, middle school teacher, and supervisor of guidance services. From 2002 to 2022, she chaired ASCA's Ethics Committee and oversaw the last 4 revisions of the profession's ethical standards. Her leadership and scholarship have been recognized at the highest level, including receiving ASCA's Lifetime Achievement Award in 2010. Please put your questions in the chat, and Dr. Stone will be able to answer some at the end. With that, we're honored to have Dr. Stone with us today to lead this important conversation.
Chloe, thank you. And Victoria, huge thank you for this honor to be able to work with school counseling and social work professionals around the nation. It's always such a privilege to be part of your work in how do we negotiate the current landscape legally and ethically in what we speak, what we say. And, there's so many pieces to this puzzle, but with the 30 minutes that I have, I would like to talk about the 4 ways that we legally speak. And generally speaking, our 4 ways of legally speaking as student service providers is substantial interest, qualified privilege, legitimate educational interest, and First Amendment speech. So if we can rock and roll through some of those and talk about what does it mean when we say substantial interest? Well, let's do it through a court case where NC versus Bedford Central School District gave us some guiding principles. In this case, the counselor and the social worker were both defendants in this court case. What happened? NC, her child, AJ, was a victim of prolonged sexual abuse at the hands of an older cousin. They had been through all of the legal pieces of that, but now mom wanted her son in the emotionally handicapped class. When talking to the counselor, she explained that she didn't want anybody to know about his sexual abuse. When talking to the social worker, she also explained she didn't want that to be part of any records or any conversations about his history and sexual abuse. Small district, if it got out, they would have a hard time. There could be bullying. So she wanted to protect that privacy. In order to forward the momentum of this placement for emotionally handicapped, the social worker wrote in the social history that there had been some abuse in the past, and the counselor shared it with appropriate people that she needed to share it with. Mom filed a lawsuit against the two, saying, "You breached my child's privacy." The judge in the case allowed the case to go forward because he said kids don't leave their privacy rights at the schoolhouse door. They bring their privacy rights with them. And this case has merit, so we're going to let it be heard. However, at the summary judgment, the judge found in favor of the counselor and the social worker because it's called substantial interest. That means when we get ready to say something about a student that is private information, careful, careful, careful. You need to be able to explain why you needed to give this information, that there was a substantial interest in forwarding this kid's education. It wasn't about just idle conversation or isn't this something that would be important to know. It is a substantial interest in forwarding the student's education. So be able to articulate between the breach or the conversations, even if it's a consulting conversation, we do consult on behalf of kids. But there has to be a substantial interest as to why we're doing this consultation. So that's one of the biggest ones. As ASCA's former ethics chair, I uh, often had to field questions from counselors who were finding themselves in hot water because they had conveyed to fellow professionals something that was highly sensitive, even prejudicial sometimes if it got out. And if they can explain that the reason why they shared it was to forward the student's education, things would go their way. We have, too many incidences, however, where some idle conversation doesn't go our way. If we have time, we'll deal with some more of those court cases. But right now, I want to move on to the second way we legally speak. It's called qualified privilege. We have to have qualified privilege, or we would be in the courts all the time, meaning that you have to be able to say something to parents so that they can understand what's happening to their child. And it's not always pretty. It's not always wrapped up with a big red bow. Sometimes it's difficult for parents to hear, but we're protected under qualified privilege. Case in point, counselor was called into a meeting with principal and a parent. Parent said, "You can't retain my child. His inability to do work this year was a manifestation of his handicap condition." The counselor said, "No, it wasn't a manifestation of his handicap condition. He could have done the work. He just didn't. He's lazy. And he didn't do anything all year." Well, ethically, we're not happy about that. But legally, because it was, well, it wasn't without malice, but qualified privilege means that you answering in response to an inquiry. Why is my child being retained? That you believe the communication to be true. You have reasonable grounds for believing that this child did not do their work this year. Of course, we would have used completely different approach to talk to that parent. In fact, let's talk, bring artifact, bring material that demonstrates what we're trying to say. But you have to have probable grounds for the suspicion. and you don't go beyond the truth or the facts as you know them to be. So you're protecting the interest of the student when you use qualified privilege. So good faith requires that we don't use inflammatory words like lazy or words that are malicious, like hadn't done anything all year. We have a better way of expressing that. But the truth is, this court case did not get legs because of the qualified privilege approach. Counselor was performing their duty, not exactly as ethically as we hope a counselor and a social worker will, but performing their duty as a counselor. The third way we legally speak comes to us from the Family Educational Rights and Privacy Act. FERPA is that law, that federal law that governs what we collect on a student and how we have to handle it. We also have PPRA, which is more, that also governs what we collect on a student in writing and surveys. PPRA is a big deal. We can't just ask kids about protected categories. I'm not going to go into PPRA very much right now, but I would like to go into legitimate educational interest as given to the school counseling profession by FERPA. Legitimate educational interest allows us to share information among ourselves without parental consent. So that counselor can talk to the social worker can talk to the school psychologist. We have to be able to share information in order to advantage a student. So it's really important that we are respectful and protective of legitimate educational interest. FERPA allows us to have that freedom to go in those records and read things and share it with other people who have LEI. You get this record and you see where a student has been in 5 foster homes in the last 3 years, transient, kicked from pillar to post. You know that teacher is overwhelmed most days with just making sure they get done what they need to, and they may not get to reading those records right away. You want to go down and talk to that teacher about her new little charge. That is allowed under LEI. What we're not allowed to do is when someone outside of our, and it has to be intentional to promote this child's education. So even if it's another educator, for example, in another school, and they're also the Little League coach, say, and they want to know what's in this child's record. I don't think this child can see. There's really not a legitimate educational interest necessarily. We might go back to that record and find that this child has failed the vision screening. We get busy and try to help remedy this situation. However, whether or not we can convey that information back to the person who's acting in the role of Little League coach, that is not something that we would do. So when they ask us next time they see us, oh my gosh, thank you for getting those glasses. Our response is, yes, nice weather today we're having. But we're very careful to respect the LEI piece of FERPA that we've been given. The fourth way we legally speak is probably the most complicated in that it is our First Amendment rights. Our First Amendment rights given to us that Congress shall make no law that takes away our freedom of speech. It's been a complicated road for educators who are in public schools because of your government. You are a government employee. So, First Amendment rights are not only what we say, but what we write, and also our actions, what we wear. If the students, for example, are having a walkout that's not sanctioned by the school, and they've all got on these orange shirts that say we need gun control, and you sympathize and you feel like you need to wear the orange shirt too, that is expressive actions. And as a government employee in a public school, and I know some of you might be private schools, so you may or may not follow along with these rules that might even be stricter for you or more lenient. It's what we do, what we say, and what we write. Government employees do not have absolute First Amendment rights. In fact, your rights are probably, well, not probably, they are more fettered, if you will, than the students with whom you work. So our First Amendment rights are very much tied to the fact that we are government employees. This person, Brian Craig, wrote a book called It's Her Fault. It landed him in a lawsuit with Rich Township High School District because he was a high school counselor. The book was designed to teach women how to better please men sexually. He used his own name, and not only did he use his own name, but he also used his job as the reason why he knew about females. Here's the foreword to his book. He said, I have 425 students, half of whom are female. Suffice it to say, I've spent a considerable amount of time around and with the fair sex. So throughout his book, he talked about his job, and that's the reason why he was so up to date on the female psyche, as he put it. He also said all females in his eyes are sexualized. So when he lost his job and he filed $1 million lawsuit to get his job back, they said, no. You don't get your job back. What child, male or female, is going to come and sit across from you? You don't get your job back, and you don't get your $1 million. And this is really not about your First Amendment. Write the book, knock yourself out. But when you wrote that book, you set up a condition, an environment in which you could no longer do your job. Here's the door, and there's not a penny of money to follow. So we've had a number of, well, too many. One is too many, but we've had other cases where social workers, school counselors have lost their job because of their speech. Patricia Crawford out of Riverside, California, lost her job when her population, 99% Hispanic, decided to do a walkout in protest of how they were being characterized by the administration. When they walked out, one of the teachers said some pretty horrible things about them. Crawford went on and added to this teacher's pretty awful post about the students and said, yes, cafeteria was much cleaner after lunch. Lunch itself went quicker. Less traffic on the roads, no discipline issues, more pleas. It got out that this counselor had said these things. And the student said, wait a minute, you're a counselor. You're supposed to have our back. And her response was, get over yourself. When she went before the Professional Practice Commission in California, after losing her job and she was trying to keep her job, they said, no, you didn't use any racial epithets. You didn't have to. The things that you used set up an environment in which you could no longer be effective in your job. So it doesn't matter if it's freedom of speech in your view, you are no longer able to do your job. So we have learned over the years, well, first of all, the Supreme Court, way back during the the development of the Constitution, that we have freedom of speech, and it's been tried in court over the years. This one during the Vietnam War back in the 1960s, where Supreme Court judge said neither students nor teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. The thing we have to remember, however, is that as a government employee, that speech can be fettered because we're not allowed to speak for the government. Sharing with you the old case that gave us this freedom of speech from Abe Fortas when the students wore the black armbands and wanted to be able to protest the Vietnam War, and they were turned away and suspended. And judge said, no. If there's not a substantial disruption to the educational process, these students should have been allowed to quietly and peacefully speak their mind with their action of a black armband. So over the years, this one in 2006, these, as a public employee, our speech has been massaged and looked at and evaluated as to whether or not what we do and what we say is protected. In this particular case, it didn't even involve an educator, but it involved someone who was a government employee. And what the upshot of this case was that from the Supreme Court of the United States is that public employees speak for the government, not for themselves. So we're not allowed to speak for the government. It's one of the most profound limitations on our First Amendment rights. If a topic is of general public concern, you're safer than if it's a personal grievance. And we want to remember that before we speak out, before we participate in, for example, an action, we have to ask ourselves, am I wearing my educator's hat? Am I safe to be doing this? Am I creating a substantial disruption? Am I setting up an environment in which I can no longer do my job? You're safer speaking as a private citizen, of course. But again, as a private citizen, if what you say stratifies your ability to do your job, it can be problematic. You also want to ask yourself, what am I speaking about? Is it a general public concern? Is it a personal grievance? Case in point, this case was just finally, the appeals court settled it in July. What happened in this case? This elementary school counselor stood on the steps of the State Department in Wisconsin and railed against policies or any kind of protection for transgender youth. She was F this and F that, and it went on. I mean, you thought you were listening to a episode of The Bear. There were so many expletives in it, where she said she's not following any district policy that allows any child to socially transition or to transition. As a result of what many considered very profane speech over a loudspeaker in public, they took away her job. So this Wisconsin counselor was fired shortly following that speech. She filed a lawsuit, and it ended this July with several lawsuits, but the appellate court this July found in favor of the school district's firing of her. They said her speech was incompatible with her role as a school counselor. Not to mention, she said she wouldn't follow school board policy. That was also an issue, but also her speech was incompatible with her role as a school counselor. So she did not get her job back, and it was a pretty ugly court case that went on for a while. But we've learned that when we're in a position of trust, and we have every state on this particular webinar, every state, you have state statute that says parents must educate their child. That means they have to give up custody and control of their child 35 hours a week. That's the only time they have to give up custody and control of their child, unless they've abused or neglected, or unless they choose to homeschool. But that's such a big deal that when a parent gives to us the custody and control of their child 35 hours a week, there's an awful long history of our where we're allowed to speak and where we're not allowed to speak. I encourage you to look at the Protection of Pupil Rights Amendment Act, Protection of Pupil Rights Act, if you're not familiar with it. I didn't have time to go over that, but that very much governs what kind of surveys you can send out and when those surveys have crossed the line. You also, in many of these states that are on today, you have a Parents' Bill of Rights that also influences what we're allowed to say and what we're allowed to ask. So I encourage you to familiarize yourself with that also. This was an attempt to take a quick look at some of what we are able to speak legally and continue to make use of your ability to speak on behalf and advocate and support students. We are protected in many ways to be that advocate and support for students through our actions, our written, and our also our speech. So I'm going to stop at this point, because I am out of time, but I wanted to see if anybody has any questions, and I'll try my best in the next couple of minutes to answer some of those questions.
Looks like we had one question come in about whether it's okay to keep client notes on the computer in a Google spreadsheet. If so, should they be in work email Google account or personal due to possibly being subpoenaed?
It doesn't really matter. It matters where we keep notes, but it doesn't matter as far as FERPA is concerned. Family Educational Rights and Privacy Act, they don't define an educational record by where it's kept. They define an educational record as something that is maintained, that is about or references or in any way points to personally identifiable information of a student. If it does, it's an educational record. For the most part, the Student Privacy Policy Office, an arm of the US DOE, they are the ones who govern FERPA. And according to them, anything we maintain that has anything to do with somebody's child is an educational record. So where it's kept is not how how we define educational records. It's is it a maintained record in the trunk of somebody's car, on a Google Doc, in a file folder? They're all educational records. And yes, please don't put it in the trunk of your car. And the Protection of Pupil Rights Amendment, I saw that question. If you're a member of ASCA, we have done several webinars, hour-long webinars on Protection of Pupil Rights Amendment. So if you're an ASCA member, grab that. It's called ASCA On Air. And you can go to ASCA On Air and put in PPRA and access those. Very important to be able to grab some of these topics, FERPA and PPRA, and delve a little deeper in some of those topics. There's no way you can keep a note from being subpoenaed. If you are in a rare state, meaning, for example, California, they do have some language that protects notes. But even then, if a judge deems that what you have written pertinent to their case, they can still get those notes. There's no way to, and we don't really need to make ourselves crazy about keeping notes private. We write what we need to write, but we filter it through the lens that if parents want it, they can get it. If parents want it, they have rights to it. In fact, they've underscored that in these Parents' Bill of Rights. So I know not every state has a Parents' Bill of Rights, but every state has FERPA. And we are under the false impression when we think that there's something actually called sole possession records that's going to keep a record out of a parent's hands. Yes, sole possession record means it's a memory aid, not shared, not accessible. But if it includes anything about somebody's child, they have a right to it.
Yeah, I went ahead and shared in the chat a link to a white paper we recently published on discoverability and protecting your documentation, which has a little bit more info on exactly what Dr. Stone was just talking about there.
I also saw a question about, well, there are a lot of questions about keeping records from being subpoenaed. I've answered those. Does substantial educational interest cover teachers and staff who do not teach a student? Absolutely. 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 And do your faculty a favor by doing a 5-minute presentation, 10-minute presentation, if you can get that much time, on the next faculty meeting. In fact, as an advocate, I encourage counselors to do a little something at every faculty meeting and stick to the time you've been given. But remind parents, teachers, that parents have an awful lot of rights to have their children's information kept private. So substantial and educational interest covers everybody under that schoolhouse roof. None of us should be talking about students' sensitive information unless we can draw a straight line between here's what I'm going to say about this student, and this is why I'm saying it, because it's going to forward their educational opportunities. Case in point, got a phone call from a counselor who said, I'm about to lose my job. I called in a child abuse report on someone who had been a child who had been sexually abused. She was being sexually abused by a parent. I came back to the office and told my 5 colleagues, my 5 colleague school counselors, because if I'm absent and that child comes into the office to see someone else, they need to know about what was said and why this child has been moved to foster and what is happening in this child's life. Well, that was not going to save her job because it's too theoretical. and it's too outstretched way out there as a possibility, way out there. It would have been different had this counselor been going on, let's say, 12 weeks maternity leave and divided up her caseload. And she said to the student, "Who would you like to have?" "Oh, you want Miss Victoria to be your counselor. Good choice. She's a great listener." What do you want her to know? Then that breach of this highly sensitive information would have been defensible. But to tell 5 other high school counselors, and I know, having been a high school counselor and an elementary counselor, when you hear these things, these trauma about kids, you're traumatized and you need to process. But we have to remember that we're not allowed to process highly sensitive information. That's not what we do. We have to find another way to process. So we are very careful, very, very, very careful that when we talk about a child's highly sensitive information, it's a consultation where we're trying to forward this child's education, or there is a reason that is defensible when we do so.
Yeah, Dr. Stone, I just want to quickly, I'm noticing the time here, and I know you have to run to a flight. So I just wanted to, I know there's some outstanding questions that hopefully we can get to after the fact in follow-up. But I just wanted to say thank you so much, Dr. Stone, for sharing your time, your expertise, and your guidance with us. I know this session was so valuable. And so I just wanted to give you a huge thank you and a round of applause. I know everyone else, we're a webinar, so we can't give you a round of applause, truly, but thank you so much. And I wanted
Victoria, thank you.
Yeah, we're really grateful for your time and so happy that we were able to have this conversation. And thank you to all of you who joined. We really appreciate the work that you're doing every day in schools and the care that you give to your students. So I wanted to thank you for that. So with that, Dr. Stone, we'll let you run to your flight and have a wonderful day, everyone.
Again, thank you for the opportunity, school counselors and social workers.
Awesome.